Has your immigration application been refused? No matter if it's a visitor visa, study or work permit, permanent residency, humanitarian compassionate grounds, you may have an option to appeal in Canadian federal court. It's best you first understand the whole process before you spend all that time and money with your legal representative. Today we're going to do a crash course in what this whole process is all about. Hello, my name is Reza and I work with the Ingwe Canada immigration team helping applicants move to Canada. Whether it's for yourself, your kids, your business, or all of the above, we do make it happen. Let me make this clear, I'm not an actual full-time YouTuber, but I work hands-on with our licensed team in Canada, working on actual applications and communicating with the immigration department on behalf of our clients, whether overseas or inside Canada. These videos are made for the purpose of sharing our hands-on Canadian immigration knowledge with our worldwide audience. And if you're thinking about immigrating, at Ingwe we break down the barriers between countries so you can study, work, or invest in the destination of your choice. We're licensed and we help applicants just like yourself and your families. The first step in preparing for judicial review, which is the step before an actual federal court appeal, is requesting the written reasons for the refusal by opening a case in federal court. The cost of getting the written reasons, all inclusive of all the legal fees and disbursements, can range anywhere from $750 to $1,000 Canadian dollars, depending on who you work with and how much they charge you. When the reasons arrive for the refusals, you may then decide whether or not to continue litigation or the court proceedings. If the written reasons show that there's not a reasonable case for federal court, meaning the case will likely fail, your representative should inform you to discontinue this litigation at no additional cost to you by filing a notice of discontinuance. Your chances of success are too low to make the whole process feasible for you. Basically, you're throwing your money away. If the written reasons disclose that litigation is worth pursuing, your representative will indicate that there's a reasonable case for federal court for continued litigation, and that legal fees to continue litigation can range anywhere from $4,500 to $6,500 Canadian dollars, depending on the lawyer or legal representative that is representing you, which are payable at the time you decide to continue this litigation to the end of the process. This could be all-inclusive, or sometimes lawyers also charge you for additional hearings in federal court, and it includes all applicable taxes. Processing times depend on how strong the case is. If it's a very strong case, the Department of Justice usually settles the case in about 2 months before going to court. And then the visa officer needs time to contact the person and have them update their files or documents for the application. That amount of time is unknown. It could be anywhere from 3 to 9 months, sometimes even longer. We've had cases where it's in less than 3 months, and some cases it's over 6 months, even closer to 12 months. If you're dealing with the Canadian Embassy in Poland, they can drag it out literally 12 to 24 months. It's crazy. Here's the description and explanation of the federal court process as follows. In most cases, it's difficult to overturn an actual immigration officer's decision in federal court with the judicial review process, mainly because the process is a judicial review process and not an actual appeal. In an appeal, it's enough if the judge disagrees with the decision of the immigration officers. In judicial review, even if the judge disagrees with the decision of the immigration officers, that is not enough to overturn the decision. There needs to be more than disagreeing with the outcome based on the merits. There needs to be an error of law for you to really have a chance. Here's the federal court process in a nutshell. There are 60 days from the date of reception of the refusal letter within which to commence the process when the refusal is from overseas. After the case is open in court, written reasons need to be received by the respondent, which is the immigration officer. It can take a few weeks for the written reasons to arrive. After the written reasons arrive, the applicant, basically your legal representative and you, have 30 days from the receipt of the written reasons to provide an affidavit, evidence, and written argumentation to the court. Remember that in 99% of all cases, you cannot add additional supporting documents or proof at this point. Everything that was submitted in your original application can be used, and all the correspondences with IRCC thereafter, which just shows you that you need a solid application from the get-go and can't change it later when you're trying to take it to court. Then the respondent, which is the IRCC, has 30 days from that day to provide their affidavit evidence and their written argumentation to court, which is called the Respondent's Memorandum of Fact and Law. There's a 10-day period within which the applicant may file a reply to address the new points of the respondent's material. That means you or your lawyer responding to the IRCC's arguments and documents. Then everything is sent to a justice of the federal court, a judge, and the court decides whether or not to actually hear the case. The court can take a few weeks or even sometimes months longer to make this decision. We've seen many cases like this drag on for months, literally. If the court decides to hear the case, the court grants leave, and the matter is set for hearing, usually within 3 to 4 months. Typically, not all the time. If the court decides not to hear the case, the matter ends there. There will be no reason or explanation given by the court for not granting leave, and the case is dismissed. It is critical for you to understand at this point that if the court dismisses the case at the leave stage, there will be no reasoning or explanations of any kind. You will not know why the case was dismissed. This is the law in Canada. If you have any questions or any issues regarding this point, you need to communicate with your legal representative, your lawyer. However, understanding this whole process and knowing the risks and likelihood of success is very important before you decide to actually start the whole judicial review and appeal process. If the court decides to grant leave, the court will order the respondents, IRCC, to submit a copy of the entire file to the applicant and to the court. The two parties, your legal representative and IRCC, may then submit new affidavits, and the parties may be examined under oath based on their affidavits. The parties may also submit additional written argument. On the hearing date, only the lawyers attend the oral hearing in court. A lot of it is now online, post-COVID. There's no witnesses, only affidavits. A federal court decision comes usually within 30 days of the oral hearing. You may be able to obviously attend this federal court hearing, and now it's all done online. So it doesn't matter where you are in the world, you can actually attend your own federal court hearing. The legal fees you pay do not include the cost of the affidavits. Affidavits can be issued by a notary, a lawyer, or commissioner of oath in your province. What can you expect of the final result of the court case? Well, a successful litigation does not necessarily mean a study or work permit, visitor visa, or permanent residency will be issued. A successful litigation means the refusal is canceled and a different officer takes over the case, but the new officer may find a new reason to refuse the application. That is always a risk in every case. There's never a guarantee that your temporary resident visa or permanent residency will be issued based on this appeal, even when there's a positive decision from the Canadian Federal Court. There you have it, the entire process summarized for you in simple terms, so you can understand the steps that are needed to be taken if you want to appeal your case, which starts with the judicial review as the first step. If you need guidance on refusals or considering judicial reviews, since you're certain that there's a bias or error of law when a decision was rendered for your immigration application, well, don't hesitate to contact us. If you're thinking about immigrating to Canada through investment, business, skilled immigration, sponsorship, or studies, you are at the right place. I can guarantee you only one point to you when you work with us. You will know what to expect, the entire process clearly laid out for you, and all the risks identified, where we can support you 100% as our client. No surprises, just results. Our team speaks over 8 languages, and we help applicants from over 47 different countries with their Canadian immigration process. Click the link below this video and get a free email assessment. And if you already know what you want, you're serious, and your timeline is clear, you're ready to go, you can also book a one-on-one consultation with me using the consultation link in the description of this video as well. And if you have more questions, remember, we're live on our YouTube, Facebook, and Instagram every Thursday 11 p.m. North America Eastern Time, where we answer all of your Canadian immigration questions for free on the spot. See you soon!